Noorsyafiqah binti Mohammad Shafihi, student ID 0360457. The beneficiary principle is a key aspect of trust law, requiring that private trusts have identifiable human beneficiaries to ensure trustees are accountable. In Malaysia, it is adopted through Civil Law Act 1956 and reflected in Trustee Act 1949, which presumes the existence of enforceable beneficiaries when outlining trustee duties. Though essential for trust integrity, the principle is often criticized for being overly rigid, limiting non-charitable settler intentions. So this raises the key question for today. To what extent is the beneficiary principle unnecessarily rigid? In this video, I will be examining the principle's application in Malaysia, its rationale, recognized exceptions, criticisms, and how local legal frameworks such as walk-off offer alternative perspectives. The beneficiary principle, as stated in Morris and Bishop of Durham, 1805, holds that every trust must have a definite object. There must be somebody in whose favor the court can decree performance. This ensures trustee accountability, as enforceability is essential to trust validity. Since trustees hold legal title and beneficiaries hold equitable interest, the absence of identifiable beneficiaries would leave trustees unchecked. The principle also supports the rule against perpetuities by preventing indefinite control over property. In Malaysia, the Civil Law Act 1956, particularly Section 3, allows for reception of English common law and equity. This includes the beneficiary principle, which has been consistently applied by Malaysian courts unless overridden by specific statutory provisions or Islamic law. As highlighted by Karim and Islam, the local framework adopts the common law structure while accommodating local conditions. The relevance of the Trustee Act 1949 is also notable here. Although the Act does not explicitly codify the beneficiary principle, it operates on the assumption that enforceable beneficiaries exist. Trustee duties such as investment responsibilities, partiality, and the duty to account are only meaningful if someone has the legal standing to enforce them. This interplay between statute and common law invites a closer look. Have Malaysian courts adopted a rigid or flexible stance in applying the principle? A key example of the principle's application can be seen in Ri Ku Cheng Tiao, 1933, where the court considered the validity of a trust for Chinese ancestral worship. Although such a trust may appear to be a purpose trust, the court upheld it on the basis of its cultural significance, likening it to masses for dead in Christian tradition. Similarly, in Fan Kin Tin and Fan Kao Fong, 1940, a trust for ancestral rights was upheld, again reflecting the local judiciary's willingness to accommodate local custom within the confines of English legal principles. The beneficiary principle is grounded in several key justifications. Firstly, it ensures enforceability as only beneficiaries have the locus standi to sue for a breach of trust. Secondly, it promotes clarity and certainty by requiring the court to identify the beneficiaries in order to assess whether the trust has been properly administered. Thirdly, the principle reflects the fundamental division between legal and equitable ownership, with the trustee holding the legal title and the beneficiary holding the equitable interest. And lastly, it guarantees accountability by subjecting trustees who are fiduciaries to oversight. Without beneficiaries, there would be no one to enforce these duties. The rationale was affirmed in Re Astor's Settlement Trust 1952, where a trust established for purposes such as promoting international understanding and preserving newspaper independence was deemed invalid for lacking identifiable beneficiaries. Enforceability is often regarded as the key element that sets a legally valid trust apart from arrangements based solely on moral expectations. Despite its strong justifications, the beneficiary principle has been criticized for its rigidity and limitations. One major criticism is that it frustrates settler intentions, particularly where trusts are created for noble but non-charitable purposes. Common examples include trusts for the care of pets or the maintenance of graves, which often fail unless they fall within narrow, recognized exceptions. The limited nature of these exceptions has also drawn criticism for their arbitrariness. In Re Endicott 1960, Lord Evershed acknowledged a few anomalous exceptions, such as those for tombs and animals, but cautioned against extending them, noting that they were rooted more in tradition than legal principle. Additionally, courts have at times adopted judicial workarounds to uphold settler intentions. For instance, in Re Lipinski's Will Trust 1976, a trust for building club premises was upheld by interpreting it as a trust for the benefit of club members, despite its original framing as a purpose trust. The importance of balancing settler intention with effective enforcement has been highlighted as a means of supporting a more flexible judicial approach. Several exceptions to the beneficiary principle are recognized in both Malaysia and the UK. Charitable trusts form the most significant exception, as they do not require specific beneficiaries and are instead enforced by the Attorney General. These trusts fall under the four heads of charity identified in Pemsel's Case 1891, that is, relief of poverty, advancement of education, advancement of religion, and other purposes beneficial to the community, which have been adopted in Malaysian law. Additionally, certain anomalous purpose trusts are accepted, such as trusts for the maintenance of specific animals, graves, and private religious masses. A further exception arises from Re Dunley's Trust Deed 1969, where a trust for maintaining a sports ground for employees was upheld on the basis that the employees constituted a sufficiently defined group capable of enforcing the trust. The concept of waqf under Islamic law provides a relevant parallel to the beneficiary principle within Malaysia's dual legal system. Unlike conventional common law trusts, waqf allows the creation of purpose trusts specifically for religious and charitable objectives, even in the absence of identifiable human beneficiaries. These are governed by state Islamic enactments and administered by the Majlis Agama Islam. The relevance of waqf is highlighted in Koh Cheng Sia and Said Hassan 1930, where the court affirmed that English doctrines such as the rule against perpetuities do not apply to waqf, in reinforcing its unique legal character. The administrative framework of waqf in Malaysia has been examined in academic literature, where it is shown to be supported by a well-established legal structure that affirms its role in serving broader societal interest. Studies further emphasize that good governance practices are critical in maintaining public trust, particularly within waqf institutions operating in modern contexts. In addition, transparency and structured reporting mechanisms have been identified as essential tools in ensuring accountability in contemporary waqf management. Academic and judicial perspectives in Malaysia reflect both adherence to and criticism of the beneficiary principle. While Malaysian courts generally uphold the principle, they have demonstrated a degree of pragmatism in recognizing exceptions and accommodating local customs. From an academic standpoint, the principle remains contested. Mary George, in her 2001 article, highlights the lack of comprehensive statutory framework governing trusts, particularly charitable trusts, which often leads to legal uncertainty and signals the need for reform. Concerns have been raised regarding the need for legal reforms that better reflect administrative realities and evolving societal needs, particularly in the context of waqf. The issue of clarity and enforceability has also been explored in relation to constructive trust and limitation periods, highlighting the importance of legal certainty. Traditional perspectives continue to uphold the beneficiary principle as a safeguard against misuse of trust structures. However, reformists argue that non-charitable purpose trusts can be valid if appropriate safeguards, such as appointment of statutory enforcer, are in place to ensure accountability. This reformist approach has begun to influence legal discourse in neighboring jurisdictions. Notably, Singapore's Law Reform Committee in its 2021 report proposed legislation to permit non-charitable purpose trusts, provided they are accompanied by an enforceable mechanism through appointed enforcers. The theoretical challenges posed trusts without identifiable beneficiaries, particularly in relation to enforcement, have also been acknowledged in legal commentary. This real-world example underscores the viability of regulated, non-charitable purpose trust, offering Malaysia a potential model for broader reform. The beneficiary principle, though founded on strong legal reasoning, can be overly rigid when applied strictly. While it is essential to preserve the principle's core function of ensuring enforceability and trustee accountability, Malaysian courts should continue to adopt a pragmatic approach in dealing with non-traditional trust. By recognizing certain exceptions and accommodating local practices such as walk-off and trust with clear ascertainable benefits to individuals, the law can maintain its integrity while responding to evolving societal needs.